All rise. We will away. Please be seated. Now, Mr. Altit, does Mr. Kabuga wish to enter a plea at this stage?
Thank you, Your Honour. This is something that we discussed earlier on. We talked to Mr. Kabuga about this before the hearing. He prefers not to answer in these conditions. I would appreciate it if you could consider his non-response as a plea of not guilty on all counts and in accordance with the rules. 64A4 of the Rules of Procedure and Evidence.
Very well. I will enter a plea of not guilty in accordance with the rules as you suggest. The plea can, of course, be changed at any time. Now, before moving to any issues that the parties may wish to raise, I would like to have an indication from the prosecution of their readiness for trial. In asking about this, I'm mindful of the extensive passage of time since Mr. Kabuga was first indicted and the duration of time he was a fugitive. In addition, some of the alleged crime bases supporting the charges are not new and have featured in prior ICTR cases. In addition, before the ICTR concluded its work, and while Mr. Kabuga was a fugitive, a trial chamber of the ICTR ordered preservation of evidence proceedings through special deposition. In this context, it would seem to me that the prosecution is likely to have completed its investigations and that, at least as it pertains to the prosecution, pre-trial procedures could be expedited. Mr. Bramett, as you're aware, Rule 71A1 requires that within 30 days of the initial appearance, the accused shall be provided in a language he understands with all the supporting material that was provided when the confirmation of the indictment was sought. I presume, particularly in view of the several months that have elapsed since his arrest, that you're prepared to comply with this obligation, and any indication that this could happen quicker would be welcome. Mr. Bramett.
Thank you, Your Honor. I will try to answer the several questions you raised. First, in relation to the indictment and readiness for trial. We intend to make a request to have the indictment amended. We will indeed, we want to streamline the charges to provide more particulars. We want to bring the indictment in line with the pleading requirements, and there are a number of changes which will be necessary based on the results of our ongoing investigative assessment. So we're preparing the amended indictment. It will take a number of weeks for us to be ready to submit it. There are a number of reasons for it. As you mentioned, the indictment was amended in 2011. it means that we need indeed to update the case file, which means that we have to go back to a number of witnesses to see if they're still available, to get in contact with them, to take their statements. And as it was difficult to organize this initial appearance, well, it is also very difficult for us under the current circumstances with COVID-19 to go back to a number of witnesses to get in touch with them. We started, of course, progressing in this regard as one mitigating measure. We have a team in Kigali. I moved a number of colleagues from Arusha to Kigali, and a number of additional colleagues have been hired just to mitigate the problem of travel. So we are making progress in relation to the amended indictment we want to submit. And the internal deadline I discussed with my colleagues would be 15th of January to be able to submit this as an amended indictment for your consideration. Now, what does it mean in relation to start of a trial, which was the part of your question? Well, we think that once a decision has been taken on the amended indictment, we would need 6 months to be ready to submit all the pre-trial filings in relation to the pre-trial brief, the witness list, and the exhibits list. The reason that it takes probably a little bit longer than one would have wished is, as I said, the problems we are currently having in meeting a number of witnesses within Rwanda, but also abroad, but also in relation to the resources. The mechanism, unfortunately, has not the same resources as the ad hoc tribunals had. There are no budgeted posts, if I may say, in relation to the trial of arrested fugitives. So we are progressing well. We are doing our best with the available resources, but those are the 2 deadlines I'm able to give today, mid-January for the amended indictment, and once a decision has been taken in this regard, 6 months later coming up with all the pre-trial documentation. In relation to the disclosure, we are fully aware of the 30 days deadline, and we will do, of course, our best to meet this deadline. What was important for us for the meeting today was to have a better understanding in relation to in what language all documents have been needs to be submitted. Documents are in English and French, partially also in Kenya, Rwanda. I understood from the intervention by the Defense Council that Kenya, Rwanda is the working language wished by the accused. So we anticipated this by asking already the registry to support us in having the translation of the documents started. We hope that these translations will be ready within the next 30 days. So we will do our best to comply with the given deadlines. But there are also still issues in relation to witness protection and protective measures we are looking at, and where we intend to get a filing ready by next week.
When you say filing next week, are you referring to these various submissions you've made, or to something in particular?
Maybe I can clarify. Prosecutor Brammertz was referring to the filing for protective measures in relation to witnesses, victims, and documentary evidence before we submit the supporting material to make sure that they are protected.
Now, Mr. Altit, do you have any comments to make on what Mr. Brammertz has just said?
Yes, thank you, Your Honour. Your Honour, as regards the evidence, we would like to have them in Kenya, Rwanda. We want that to be clear. For the remainder, we have taken note of what the prosecutor has said. It's too early at this stage for us to say any more. Everything will depend on our analysis of the elements communicated to us by the prosecutor, and at that point we'll be able to give you our position.
Thank you, Mr. Altit. Mr. Brammertz, one particular issue, in case the situation is different in any respect. I'm speaking obviously from a historical experience rather than recent direct experience, but one issue that seems to, disclosure issue which seems to create difficulties from time to time is the timely and effective disclosure of exculpatory material under Rule 73. Particularly because it can be fairly disorganized and presented in a form that can be difficult to research. Do you have plans afoot to try to simplify that exercise?
Thank you, Your Honour. I know that this has been a challenge in the past in a number of proceedings, and want to make this very, very clear that for us as of the prosecutor, the fairness of the proceedings is extremely important, and we discussed also within the team the importance of having exculpatory material very disclosed on a regular manner every time we discover this material. So we are fully aware of this issue, which, as I said, has a very high priority in our office, and we will make sure that this material will be disclosed as soon as possible every time it is discovered in the context of the review and investigation.
Thank you. Is there anything you wish to say on that, Mr. Altit?
Let me add something at this point, Your Honour, if I may, before we adjourn, concerning the state of health and the upcoming motion that might be filed by defence.
That in a moment, if you don't mind. Thank you. The reason I've interrupted you there is that I was going to say something about reviewing the indictment, and it was music to my ears to hear Mr. Brammertz take the initiative on that, and I look forward to seeing the results of that exercise. So far as the various indications of the timescale are concerned, I will reflect on what has been said, and I will issue a decision which I hope will guide your pre-trial preparations. I can't indicate just how quickly, but it will be pretty quickly. So it's important that we take the initiative at this stage. And I say that for two reasons. There is clearly scope for making this indictment more focused and streamlined, as you have agreed. And that should be done having regard to the need for both a fair and representative presentation of the prosecution case and the reality of this particular case, that it should commence and conclude as swiftly as possible for reasons which must be obvious to everyone here. Now, that has to be done having full regard to the health of the accused, and I note that Mr. Altit wishes to say something on that matter now, and I'll hear him so far as he considers it appropriate at this stage. But I hope that in addressing me, he will also have regard to the need to deal with this as expeditiously as we can, having full regard to fairness towards the accused, Mr. Kabuga. Mr. Altit.
Thank you, Your Honour. It is precisely on that path that I would like to move along and make a few comments. We must move expeditiously, but we must be cautious and careful. And we must, I think, above all, bear in mind Mr. Kabuga and be aware of his state of health. I think that is the priority here. And once we know more, we will then be able to move ahead more quickly, but on safe ground. As far as the defense is concerned, the way of guaranteeing fairness of the proceedings is as follows. We must make sure that the procedure that has been initiated, whereby we want to identify the state of physical and mental health of Félicien Kabuga, should be seen through to the end quickly, but entirely and in detail. It is important that the parties and you yourself, Your Honour, and the trial chamber should have a full view of the situation. The sooner that we know what the situation is, the better we'll all be able to move forward together. And once we know more, Your Honour, the defence will be able to submit applications that we think will be useful. For instance, an application with a view to determine Félicien Kabuga's aptitude to be trialled or lack thereof, or, for instance, an application with a view to his being released on a provisional basis. We think that it is crucial that we move forward very quickly on these issues, because this is where we feel lies the interests of justice.
Well, you've all heard me at an earlier stage in the case today mention the issue of the medical assessment and the importance of having it done and completed as quickly as possible to give you the opportunity that you now seek to draw other matters that you think ought to be addressed to the attention of the court. So that, having been mentioned, will also be dealt with further in the decision I've referred to, which I will issue shortly. Now, is there any other matter that either the prosecution or defence wish to raise?
Pas d'autres points, Monsieur le Président.
Your Honour, I have nothing further.
Very well. That concludes today's hearing, and I thank the parties and adjourn these proceedings pending the issuance of the decision to which I've referred.
All rise. We will leave.